of citizenship, you can't do it in federal court. Federal courts tend to actually move faster than state courts. They tend in some ways to be a lot more professional. So if I had my brothers and I was representing an energy company, I would prefer to go to federal court. Okay. The question of legal fees, we talked a little bit about that before. In England, the winning side gets their attorney's fees. We have what's called the American rule, and in the American rule, you pay for your own attorneys, whether you win or lose, unless there's a fee-shifting statute. And we're not talking about that in oil and gas law. There isn't. So basically, if you bring a case involving zoning regulations or bans or whatever, basically you will pay for your own attorney. Win, lose, or draw. You can't get the court to give you your legal fees. Okay, in the state system, the state system is set up, you have some local courts, like your town justice court, or the small claims court, or city court. The lowest court in New York State, the lowest court of general jurisdiction, is called the state Supreme Court. And that sounds really kind of strange, because why would you call the trial court, the lowest level court, the state Supreme Court? And that's a little bit of history. That's the way New York State, when New York State began, they considered that the most important court of the land. And so they called it the Supreme Court, and they've never changed the terminology. If you, and when you're dealing with the lowest level court, if there are any factual issues to be decided between the parties, that's where you get your trials. That's where people get on the stand and raise their right hand and testify. Once you get past that level, and you go up on appeal, the issues on appeal are legal issues. You don't have the witnesses paraded back into the courtroom. You don't try the case over again. Basically, the law then gets decided on the legal issues that are presented to the court, and often done on paper, sometimes a little oral argument. Most of the cost of the case, where there's factual issues, actually comes when you go to the trial court. It takes more time. He said, she said, that takes time in the courtroom. So, when you start in the Supreme Court, the state Supreme Court, one of the things that, because there are two decisions out there right now regarding bans on fracking. One of the things you need to remember about that is that at the state Supreme Court level, the justice who gives you the opinion does not set binding precedent. Because that decision does not even bind another judge in the state Supreme Court hearing another case on pretty much the same issues. When the case gets to the appellate division, which is the next level up, we have 4 judicial departments in New York. And the decision that's made by the appellate division of your department is binding in your department, but only in your department. This New York State's highest court is the Court of Appeals, and cases that get to the New York Court of Appeals, when they issue a decision, it's binding throughout the state. So you really don't get an answer to issues like, did the state preempt local zoning ordinances, until you get a decision out of the Court of Appeals. Until then, you've not got a statewide binding controlling precedent. And once you get that, then every judge below is going to be constrained to look at that as binding precedent. So when you hear about a decision, you always have to ask yourself the question, the people who win the state Supreme Court case are going to tout it in the press as though it was a binding decision and everybody was bound by it. If you lose the case, then obviously you're going to say to the media, the battle's just beginning. We have a ways to go before we get into controlling law. And we do in New York State right now on this issue. And a long ways to go, because we've had 2 state Supreme Court decisions about local bans. Yes?
I have a question, sir. It seems to me that this asking for misleading, because most of the litigation is about fracking. Does that mean you can drill any place you want to drill, you just can't frack?
You can drill where you have a permit from the DEC. And it is still legal in New York to get permits for vertical drilling, for vertical well drilling. Right now, of course, you can't get a permit anywhere in New York State for horizontal drilling. The question then arises, if you do ultimately, let's say late 2012, sometime in 2013, the DEC begins to permit horizontal drilling. Then the question is, if a local town has an ordinance against it, does that local ordinance, is it legally valid and effective? And that's the question you answer first, because if the ordinance is invalid, okay, then you can go ahead with your state permit and do your drilling. But if the ordinance is valid, that's what the courts ultimately decide at the highest level, and the ordinance is valid, then the next phase of the litigation, and I'm not making this up, Tom Westner's the attorney for Anschutz has already said this in the media, the next step in the process is for the industry to file a takings case. Because the United States Constitution provides that you can't take property without compensating people for it. And that's the question that will be litigated after this one. Okay. Then also, because the nature of this proceeding is what it is possible for people to bring lawsuits on the basis of whether the ordinances were adopted procedurally properly. The cases currently pending in New York do not do that. They don't go to the question of whether town X or town Y or town Z followed proper procedure. And I'll get to the reasons why that is the case in a minute. But that's what's currently pending in the courts. So no one's raised the question about whether the particular towns followed the law when they adopted their ordinances. Yeah?
What do you have to say about New York State Department of Agriculture and Markets, Agricultural Districts Law, Article 25AA?
Well, the agriculture marketing law applies when you get into zoning questions. Towns and villages don't have the right to zone out agricultural use. New York State's pretty clear about that.
Because the way this reads, it's against the law for a town government to make a law that's contradictory to an already existing state law.
Yeah, that's the principle I mentioned before about general state laws. And that's part of the issues that are being litigated now in the ban cases. But as far as agriculture is concerned, there's also the agriculture markets law. And the agriculture markets law protects people who are in farming from zoning that relates to their farming activities. So for example, one of the reasons they did that was because if you use fertilizer, for example, people who live around you might object. And enough people would object if the state felt that they had to protect agriculture. And they did that by agriculture and marketing law.
New York State Department of Agriculture and Markets provides free legal assistance to participating farmers facing unreasonable, restrictive local ordinances or neighboring nuisance disputes.
Okay, are you a farmer?
Yes.
Okay, you have that recourse that those of us who don't farm don't have. But you definitely have someone you can go to, and ag and marketing is pretty protective, as they should be in those circumstances.
They shouldn't be. Towns shouldn't be allowed to pass laws that are contradictory to already existing laws. Then they're going to do it.
Well, you're right about that. That brings the point up that I was making before about if they do it though, if they use raw power to pass something like that, and you think that it's improper, what's your recourse? Well, one recourse, of course, is to try to vote the people out, but you have to wait a couple of years to do that. Another recourse is to go to the media. But as far as the law is concerned, why don't you just bring suit? Bringing suit. If I'm on a town board and I know that I'm going to pass a bunch of things that are dubious, I also know that you as a citizen are going to have a very hard time contesting it. Because where are you going to get the money? I can thumb my nose at you and say, okay, you don't like it? Do something about it.
Well, in this case, ag and markets.
Yeah, I mean, you go to them, try to get help. They may or may not help you. But if you want legal recourse yourself, the problem is that you end up having to pay for it. or finding enough other farmers, or maybe the Farm Bureau or somebody to help you finance a lawsuit. But then if I'm the town board again, I'll just pass one law after another, right, so that I tie you up and you're going to have to do a whole bunch of them, and it's going to cost you more money than you know what to do with. I'm trying to say to you here that one of the bad things about the legal system is that there's not much justice if you don't have much money.
Henry, two things. When you go to the appellate division, does winning or losing in the Supreme Court have any effect on their decision, on when they look at it?
Yeah, they will look at they'll always look very carefully at the decision below, because it is entitled to some weight. When I said it's not precedent setting, I didn't mean that another judge won't give it some weight. And they will certainly look at it. They do reverse decisions of judges below them. But there's no guarantees. I mean, they think he's wrong. They may reverse it. One of the things I'm trying to say here, Tom, is that all litigation is somewhat of a turkey shoot. I mean, no matter how good your case is, you can have the best case in the world. I think that the cases on bans right now that were decided in the Supreme Court, my personal opinion is they were wrongly decided. But that doesn't matter, because the question is, what is the law? And the courts decide what's the law, not me. I'm entitled to my opinion, you're entitled to your opinion, and as we go through and look at the preemption law later, because I want to look at it with you almost a little bit word for word, so you can draw your own conclusions about what it means. Anybody can stand up here and tell you the law says this or that. Part of my mission today is to go over that law with you, tell you what it really says, exactly what it says, and then let you draw your own conclusions as to whether you think the decision was made right or made wrong. You're just as entitled to make that decision as I am. Any person can read the law until you have a binding decision. Yeah, you have a question?
My understanding is, I don't know this to be an evidentiary fact, there was early regulation where towns and municipalities tried to regulate crops growing. And an early ag market decision was that a farmer could regulate or grow any crop that he wanted.
Yeah, that's again because ag and marketing and the ag and marketing law, different kind of statutes, very protective of the right of farmers to do those things. And it's protective of them because if you didn't do that, what you get in the way of output from farms and the resistance you get from some people in communities that don't like their farms very much, they would be able to interfere too much in farming. So the state made a decision a long time ago with the ag and marketing law that local zoning power doesn't extend to the kind of thing you're talking about.
We also have big slurry tanks that are generating methane right now. We're using it. So we've got a decision on methane nutrient production because we've got cow
Manure.
fermenting, we're stirring it, and generating methane. Sometimes the farmers are using the methane, and Ag and Market says you can generate, use, utilize, or even sell that methane. So how can any town supersede Ag and Market's law that's been in place for 100 years?
Well, they can't in that instance. Right? Now, again, if they try to do it, what they're going to run into is they're going to run into some resistance. And the question is, what do you do when a town does something that they're not supposed to do? And I'll skip ahead a little bit here to talk to you a little bit about town boards. Town boards are very different than Congress or the state legislature. In Congress and the state legislature, you have two houses, and a bill has to be passed through the executive for a potential veto. So you've got some checks and balances in the state level and the federal level. When you get to town boards, you've got 5 members sitting on the town board, 3 of them control. They can do pretty much anything they want to do in the first instance. And there's practically no check on them. Well, it turns out the town board job is a very powerful job. It hasn't been historically in New York State because town boards can find themselves self-restraint. They can find themselves the kind of things we expect towns to do. a little bit of police power, roads, a little bit of planning, but not this kind of thing. And as this oil and gas thing is developed, town boards have started to seize more and more authority and to pass things, even when they may know that they're of dubious legality, because it's very hard for the citizens to challenge.
And, you know, it's interesting you're saying that, because one thing that I can report on, and this is anecdotal, but it was a situation in Enfield with the wind farm. If anybody knows John Ranch, who was the developer of that project, he initially got turned down for that project, and there was a law against it. That town board was turned over within a very short period of time, and that law was rescinded very quickly. So there's potential of it also working quickly too, but it can be really messy. It all depends on who has the power in that township or that municipal, and how much power they have, and who they can keep in place.
Now, one of the concerns about town boards is that in addition to the fact that if you have home rule in this area, a town board can change hands every 2 years. You elect supervisor, not the supervisor, but members of the town board. It's possible for a town board to flip over every 2 years in terms of who controls it and what their agenda is. And of course, approximately every 10 miles as you drive, you move from one town to the next, right? So that the rules change as soon as you leave a town. So you have a spatial patchwork, and then you also have a time patchwork, because, as I said, every 2 years, if the town board keeps slipping back and forth, a closely divided town between people that are for and against energy development could change the law every 2 years. And that's one of the reasons why when the state talked about the environmental conservation law, when they passed the current version of that, they tried to talk about state uniformity. They did that in part because, I'll give you a little history here. When vertical well drilling came into New York, and with hydrofracking, because they've been hydrofracking for a long time, when it came in, about the vertical wells, about 1970, thereabouts, when they started putting those into numbers, localities jumped into the breach and started passing local ordinances about drilling. And the patchwork quilt that I was just talking about developed across New York State. When the legislature passed the current version of the environmental conservation law, the oil and gas and solutions law, they passed it in part to stop the patchwork quilt. And because that happened 30 years ago, a lot of people have forgotten why that happened in the first place. Because New York did experiment with that. And one other thing that happened is down across the border, some of you are very close, people from Vestal, you're very close to the Pennsylvania border. In Pennsylvania, they had local home rule. And under local home rule, towns were able to zone and regulate the energy development industry. Well, in fact, the judge in the recent case in New York looked at Pennsylvania law. There's only one problem. Between the time he looked at the law and the time he wrote the decision, the state of Pennsylvania repealed home rule. And they repealed home rule thoroughly in Pennsylvania. They did it because it wasn't working. You know, the patchwork quilt again just was not working. And when they repealed the law in Pennsylvania, they went so far as to make statements in the new law, there's provisions of it, that specifically enjoined towns throughout Pennsylvania that they must permit under zoning some development. Jim?
But that requires common sense, Henry. Ken has a contiguous piece of property in 2 townships. One is against, already done now, and the other one is pro.
Do you have any land that actually spans the border and spans the town line?
Yes.
Well, that's interesting. You could be the first test case on doing something in a town that doesn't ban it, and goes into a town that does.
I've also built my own 4 million gallon lake, so I've got my own water. I've got my water, I've got my location. I had a company interested in it.
So you're in a good location to do something. One other thing I need to talk to you guys about a little bit is the nature of land ownership. Historically, when people got land in the United States, before that in England, most people acquired their land in what lawyers call fee simple absolute. You had a warranty deed, and you acquired your land in fee simple absolute. So what did that mean? That meant basically you were the lord of the land. You could do almost anything you wanted with that land, short of creating a public nuisance. If you decided to have a rat colony, the health authorities could move in. But basically, you could do what you wanted. You owned the land, okay? And most of us own land in fee simple absolute. That means that our ownership rights at common law go down to the center of the earth, down, 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 narrowing down until you get to the center of the earth. And then when you get to the surface, they go up. They used to go up forever. But then the little thing called Sputnik happened, and the space programs, and the law had to change and adapt to that. So now there's an upper limit to how far up your rights go. But as a surface owner, unless you have somebody that's got mineral rights, you own the land all the way down. Now, you can sell the mineral rights separately. You can sever the mineral rights. You can own them yourself, or you can sever them and sell them to somebody else. And it's an interesting fact about mineral rights that you can sell them in layers legally in New York. So I can sell a company mineral rights from 5,000 feet down to 8,000 feet down, and sell somebody else mineral rights from 4,000 feet to 5,000 feet down. So you can actually have multiple subsurface rights. Towns cannot zone below the surface. It only relates to surface rights, not to below. An interesting case on this, when this stuff got started in the 1920s, there's a case called Pennsylvania Coal. And Pennsylvania Coal, because it was decided way back when, put a tremendous emphasis on your rights as a landowner. As a landowner, if you own the surface, but down below you, where somebody was mining coal, which happened all over Pennsylvania, if the coal miners decided to take out enough coal from underneath you that your land subsided or fell in, Pennsylvania court said basically that's too bad. You don't have primary rights. The mineral owner had them. So you can imagine why in the 1920s coal companies in Pennsylvania were pretty powerful. Since then, of course, things have changed.
Is that the rule of capture?
No. That's a separate thing. That's about the rule of capture, and we want to take it up right now since you asked about it. The rule of capture basically says that, it's an old common law doctrine, started out with people hunting. Right? If you caught the fox was yours. Right? But they converted that over into the oil and gas thing. And it's basically the first to get there that gets the gas. So I drill a well in Pennsylvania, and I rush it through to completion so I can get my gas, I get the gas first. And I start pulling gas out. And the gas migrates from my neighbor's land. Well, in Pennsylvania, that's just tough for the neighbor. It's an incentive actually to put wells in quickly and somewhat hastily.
So they can also horizontally drill into your property line?
Yeah, and if they do that...
That would be trespass. If they actually drill it.
No, but they can pull the gas from your property. And if they do that, they don't have to pay anything. It goes to the person who's got the land with the well. New York does not have that. New York adapted and did what we call compulsory integration. And a lot of people, when I go to meetings sometimes, people talk about compulsory integration. They put the emphasis on the word compulsory. And they think it's an awful thing. You know, New York State is going to force me into a spacing unit and force me to participate with these other people. Actually, it's a protection for people. Unlike Pennsylvania, which is the old law, the law of capture, in New York State, if you are in the block from which gas is going to be drained, and it's usually about a square mile, In Pennsylvania, they're going to 2 square mile blocks. But New York still technically talks about 1 square mile. If you're in that block and they're taking gas in that block, you're going to get to participate in the profits of that. And so the argument is that compulsory integration is a much more modern concept of law of capture. It's more protective for people because it shares the wealth.
In regard to that, I do believe that you have a couple of folks that have been running around Hopkins County. You're a Steve Assemblywoman, and maybe Steve May from the Trust Company, scaring a lot of people, in my opinion, regarding what you're talking about, surface versus subsurface, surface deed versus, and help me here because I think it's wrong, but mineral deed. And one of the challenges is scaring people to thinking, which made me chuckle, because the USDA came out and said, if you're going to do gas leasing, whatever, they're going to no longer provide mortgages. Somebody got to that real quickly, about 2 days later, the Wall Street Journal, they came out that that was withdrawn.
Yeah.
But in the meantime, there's a scare going on in our part of the country regarding banks' mortgages and insurance.
Yeah.
And if we were like maybe the state of Pennsylvania, or as I understand, maybe Alaska, if we had surface deeds versus mineral deeds, and the banker only took interest in the surface deed, and then the commercial activity took place underneath, there wouldn't be a problem with selling the Fannie and Freddie Mac, because that's done all across the country in that manner. And in addition to that, some insurance companies have indicated that through compulsory integration, somebody was to conduct hydraulic fracking underneath, that would constitute commercial activity, which would violate their homeowner's policy. And again, separation by deed would eliminate some of those challenges. Looking for, I don't know why I'm sharing there, but I know it's a big challenge. We need to get counsel in New York State, real property in New York State, real estate attorneys in New York State to really start looking at this and suggesting to people how we might be able to accommodate various subject transactions.
Yeah, the law sometimes takes a while to catch up. For years, they for a lot of things they wouldn't accept a fax of your signature or an electronic signature, and it always takes time for the law to catch up with the technology and with what's going on in the world. So, like the space law thing about how high up does your property rights go, the law's got to adapt as the world changes. Property rights law. I'm not a real estate lawyer, but property rights law is pretty static stuff. If you're a real estate lawyer or a real property lawyer, the law that you have to work with doesn't change a lot. In my particular field, labor relations law, a law changes real fast. Civil rights law changes real fast. And oil and gas law is evolving and developing. It's rapidly changing law because we're just learning more as we go along. With regard to the mortgages, I mean, one of the questions the mortgage companies are going to have to ask themselves is if they don't write mortgages for people that have mineral rights under their land that's separated, there's a hell of a lot of New York State they're not going to be able to write mortgages in. Right? Because as this goes on, there's going to be more and more of this separation. By the way, you may be better off. I had this talk with Ron a while back. You may be better off as a landowner to separate your mineral rights from your surface rights, okay? And put them in, say, a corporate name. Set up a corporation, put them in corporate name to separate them from your own rights. Right? One of the reasons for doing that is when you get into the takings law, when they have to compensate you. What's going on now with the cases that are now pending is that Anschutz, for example, the company that's suing Dryden, they own only mineral rights. They do not own any surface rights. Okay? So if they can't do anything with their mineral rights, if they're prohibited from doing it, it's 100% taking. They've taken the entire value of their property. Whereas with a landowner who also owns the mineral rights under their land, they've diminished the value of your property, but they haven't taken away 100%. Separating surface ownership from mineral rights can allow you to get around that problem and put you in the same position as the energy companies. Why is that important? That's important because, as I said, the 100% taking gives you a much better chance of success, and it makes it easier to measure the damages. For companies like Ansys has invested $5 million in buying leases in the town of Dryden. Their damages are pretty clear. I mean, if they don't sue for royalty damages, if they sue for taking just what they spent to acquire the leases, they're going to be suing the town for $5 million. The town's budget, that's many years worth of the town's budget. You as a landowner who may have a similar suit have a much harder time proving your damages. So your chances of having a successful taking suit are not as good as the industry's. The principle that's being tried in both the industry case and the landowner case is pretty much the same. But when it comes to compensation, you're in different situations. And one of the ways to make that cleaner for a landowner is to separate your mineral rights from your surface rights. Jim?
Just one little follow-up, sorry.
Sure.
One little follow-up to that is, in my understanding too, if you have not separated those, and you've only done it by reservation within deed, please hear God, I'm not fully clear on what I'm sharing here. But it is my understanding that if I owned 100 acres and I no longer had an interest in the surface, and I sold the surface but retained the subsurface, if I did it by reservation of the deed and the surface owner did not pay their taxes, I could lose to county foreclosure my interest in that property if I didn't pay the taxes, versus if I've separated those two parcels with a deed, then I don't have that same concern. Is that correct?
You know, I can't answer that directly, not being a real estate lawyer. But I can say this. Whenever you do anything like this, you've got to look at all the ramifications of what you do, okay? And be very careful, because there are usually cons to go along with the pros. This is something you don't want to do on your own. You want to get somebody who's an expert in this area of the law to work with you to make sure that those kinds of considerations are brought out. Jim?
Maybe an ignorant question, I'm just very curious. You can get a permit now for EC to vertically drill and hydrofracture.
Yes.
Okay? Is the hydrofracturing, is it a single permitting process so that, I mean, can't you just drill without the fracturing? And if that's the case, when you're getting a horizontal drill done, is the hydrofracturing always part of that? Can't you just go and drill like this and you're not going to you're only going to hydrofracture down to the horizontal point?
Well,
The whole thing.
what I understand is that economically that doesn't work. You can't. The reason that people hydrofrac is because the layer of gas-bearing material runs horizontally, and you go down very far, and you've got this layer. It's not that thick. So if that's all you can take out, if you don't fracture to get more,
So
the cost is prohibitive. It's not an economical proposition. And that's the reason, as I understand it, why people do hydraulic fracturing is because you can't get enough out. The other problem is with vertical wells. If you were to put vertical wells in to get the same amount of gas out, where they use one horizontal well with like 12 pipelines off, you'd have to have something like what?
They say 32.
32?
Chesapeake says it's 32 to 1.
So for every square mile you're drilling, if you're using fully vertical wells, it'd be 32 wells. Versus
Yeah,
one
the
horizontal.
equivalent, yes.
That's one of the things you use to tell the environmentalists that this is less impact on the surface.
Yeah.
Henry, I do have some information on that issue, though, with regard to what you're saying, Jim. Norris Energy, I think you understand that they are also in New York State. They have done exactly what you've said, and they have drilled horizontally. I spoke with one of their key managers there, trying to find a workaround to the law, because as long as they weren't using high-volume hydrofracking, which is part of what the new DEC regulations are, they can still drill horizontally. But the question is, like Henry was saying, how successful is it? And that's what they were experimenting with. They were trying to do some of that in Shenango County, I believe it was. And I don't know what the results were. Obviously, I don't think they were that successful with it. But there are some experiments that
Like a
way.
savings account, you're investing for the future.
Yeah.
Some areas are getting sands, some areas you're not running into straight shield, they're running into sands. If you're running into sands, you don't need frac.
You don't need frac.
That's what they're looking for now, is they're looking for the sand deposit that's not shale.
You're right, it was a different shit, you're right, because they were different layers. It wasn't the Marcellus.
That is-
Yeah.
Is
Is there a question over here?
I was under the impression that in Tioga County, is that the county I'm in, Tioga County?
So here, yes, you're in
Oh,
Tioga.
okay. I drove forever to get there. Anyway, I understood that Tioga County has some sort of a proposition going into the works to be able to do the first gas frac type of procedure, and I have been talking with these folks for a couple of years now out of Texas and Canada, so I just wondered, have you heard since you're here, is this?
Yeah, there's a sort of a large landowner group, attorneys representing a large group of landowners who is negotiating.
E-Corp.
Yeah, exactly. And, you know, the question is, if they use propane instead of water for the fracking, can they make that workable? Because then there's no problem with the water at that point. The next question you're going to get from the people who pose this is, what does it do to the air?
Gas fracking is currently covered under the 1982 regulation. It's good to go, according to the DEC.
Now, the environmentalists, they're coming out this bad.
Oh, yeah, because it causes earthquakes.
So I say, let's go to California on the San Andreas and start gas fracking. You see, California from falling into the ocean.
I was thinking maybe pushing them.
Well, look at that, too.
We'll take one more, then we need to move on.
There
Ken?
is a proprietary fracking technique that's organic.
Mhm. That's what I have to, what do we know about that? Yeah.
It's hard to hear him when you're behind him.
Oh,
Can you
okay.
paraphrase what you're saying?
What I can do probably is that's a wired mic.
Have him turn around.
There is a proprietary, non-discussed, non-disclosed that the industry is waiting for. There's an organic frac. And I have seen it done 35, 40 years ago.
And is that Alberta, Green, right?
I can't say anything. And I don't work for an oil company. It's in our best interest just to know that it's there.
Okay, I'm going to change subject here a little bit. And I want to talk about the two cases that are pending in New York right now. There are two cases. One is Anschutz v. the town of Dryden, and the other one is CHC versus Middlefield, town of Middlefield. The first one is an industry suit. The second one is a landowner suit. And they started out separately. The industry, of course, bankrolled Anschutz for the Anschutz suit. Landowners contributed some money to the landowner suit. And currently, the two cases are in the process of being consolidated. Okay? So when they go up on appeal, since they present basically the same issues, they will be heard together in the appellate division and in the Court of Appeals. And Tom West, who is the counsel for Anschutz, has become the lead counsel in the combined cases. The other attorney is Scott Kurkowski, who's from Binghamton. And they're working together on these cases now. Okay, where are those cases? Well, we've had two state Supreme Court decisions. One from Judge Rumsey and one from Judge, I think, Ciccio. They would have coordinated their decisions because there's so much alike when you read the decisions in depth. Now, you need to know that these two lawsuits are what they call Article 78 proceedings. And they're Article 78 proceedings because what they are doing is challenging, and it's the only thing you can do in a 78 proceeding. They are challenging the validity or the power of the town boards of Middlefield and Dryden to pass the zoning ordinances that they passed. That means there are no fact issues. The whole case has been done basically on papers and argument, no trial. It's faster. And when I talked to counsel when these cases were being filed, one of the questions I raised is, which way are you going to go? Are you going to challenge the ordinances in each town? Are you going to do a test case? Are you going to sue against the process that was involved in zoning? What are you going to do? Okay. And the decision they made was to go with an Article 78 proceeding. Why? It's faster. You're going to get a much quicker resolution with it. But there's a whole bunch of causes of action that could be brought regarding what towns did that can't be brought up in an Article 78 proceeding. Those are still out there. They can be brought up later or by other people. But as far as the proceedings that are going on in New York State now, the sole legal question is the authority of the town board and whether they've exceeded their authority when they pass these blanket zoning bans. Okay, now, when the cases were argued, when Anschutz particularly was argued, they wanted to bring in, Tom West wanted to bring in some of the legislative history of the law, the environmental conservation law. And they could not find, when the bill was passed in New York State, it has what they call a bill jacket that goes with it. In the jacket are the recommendations of the governor and so on about what the bill is intended to do. Well, unfortunately, New York State lost the bill jacket. You know, they moved from location to location, they stored the records, they lost the bill jacket. Couldn't be found. Right? There was a diligent search being made by and they did ultimately find the bill jacket, right? But not till after the decision had been made in these cases. So there is a motion to renew pending, where they're asking the judge to take a look at what they found in the bill jacket, which talks more about a uniform state system and more about the state's intent. That was supposed to be returnable last Friday, but counsel for Middlefield and counsel for Dryden requested a postponement. They were unavailable for that date. Okay? And now that motion to renew will come on June 1. Okay? Tom West tells me that it's legitimate, that it was a legitimate request, but you have to wonder whether it was arranged for counsel not to be available in order to slow this thing down.
What about the author of the preemption that his former legal counsel was the judge? Why was that never raised?
Well, first of all, both judges threw out the former counsel's testimony. He submitted an affidavit, and they wouldn't take it because it was an after-the-fact affidavit. Basically, they didn't want to take it into the case. There's a very interesting comment that was made a long time ago by Oliver Wendell Holmes, Justice of the Supreme Court. The young man was appearing before the court, and he said to the judges, look, on the precedents that exist on this case, that you have no choice but to rule for my client. And Holmes leaned over the bench and said to him, young man, if this court wants to rule against your client and wants to override the precedents, it will not only do so, but it will find appropriate language to justify it. So I have to believe that in both of these cases, when the judges wrote their opinions, they were determined to find that state preemption did not exist here. And I'm going to talk a little bit about what they did. Ask you to judge for yourself, as I said, about the statutes. So just to finish up on this piece, the expectation is the motion to renew will probably not be granted, and that this will move on to the appellate division, and we will get a decision on these two cases about local preemption sometime around November. Okay? And that will be the appellate division level. Whatever the decision is, expected to be appealed to the Court of Appeals. But I just wanted to give you a little piece of the timetable of what's going on. At the moment, these cases don't set precedent, but that's where we are. They're out there. They're going to be cited by people in the public. Okay. Let's talk about.
After it goes to the appellate and gets repealed, how long is it likely to be before we really know what the final outcome is?
I would say you probably will have to wait until about 2014, maybe early 2014. These things have a tendency to get slowed down, and we won't get the definitive answer probably before then. Of course, we're not going to get any permitting in New York until 2013, so a lot of the towns that are considering moratoriums and bans right now, the question that you need to ask them is, what's your hurry? You know, with no permits being issued, other than making a political statement, what's the point? When you pass a ban or you pass a moratorium now, you're just inviting the potential for a lawsuit. So you're better off just waiting. Why take a risk?
And Henry, also, aren't moratoriums time limited?
Yeah, moratoriums are, tend to use them in towns that don't have zoning. Okay? But a moratorium cannot be indefinite. There are court decisions that say you can't have an indefinite moratorium. You can have a temporary one, you can renew it, but anything much more than about 2 years is going to get an organization in trouble.
Yeah, I've heard the argument for that when they say, let them do it now, so by the time it's over, permits will be issued, so let's push them to do the bans now. That's one of the arguments.
Where did you come up with 2013? Where did you come up with the 2013 date for permits?
I'm just estimating.
Because the governor had 105 days from January 12th to make a decision, and that's expired, he hasn't done it yet.
Yeah, but there could be one reason or another why the state just puts it off. But even if they do it on time, we're already in May. One way or another, I don't think we're going to see very much. People talk about late this year. My guess is that for one reason or another, it's not going to happen late this year. There tends to be built-in delays in these systems, and they keep coming up with one delay after another. I think it will take some extra time. So?
Does the Court of Appeals, the highest court in New York State, have to take all appeals, or is it like the federal Supreme Court that can only pick and choose?
They do have a choice. If you get a split decision in the appellate division, there's some circumstances under which you can go by right. If the judges in the appellate division certify the case, if there's a split, I think you can go up by right. But basically, the Court of Appeals has, like the Supreme Court, has discretion about what it takes. This is not a case I would see them passing up.
But if they were to pass on taking it, would the appellate division then rule for the entire state, or are we still restricted to one division?
Still be one department. It's sort of like the courts of appeals in the U.S. federal system. You know, you got a whole bunch of different U.S. courts of appeals, circuit courts of appeals around the country. Sometimes the law is different in different circuits. If the Supreme Court doesn't take it, the law still stands in each of those circuits, and it can actually be interpreted differently. When you have a split like that, there's a tendency for the court to take it, the U.S. Supreme Court. Not always. But in New York, there is some discretion in the Court of Appeals about what they hear. There are some ways around that. Okay. What I wanted to talk about a little bit now this Article 78, these two Article 78 cases, is the preemption statute. And this is one of the few cases where I may actually read you something because it's kind of interesting. And I think you need to know what the... First of all, there are two different statutes in New York, the oil and gas law and the mining law. Okay? And in the two pending cases, both judges said there is no material difference between the two statutes. They're essentially the same. I'm going to read you something here, and you decide for yourself whether they're the same. Okay? The oil and gas law says the provisions of this article shall supersede all local laws or ordinances relating to the regulation of oil, gas, and solution mining industries, but shall not supersede local government jurisdiction over local roads or the rights of local governments under the real property tax law. That's the whole thing. It's the relevant provision. And I would emphasize it says all local laws. Right? And then it says at the end there are two exclusions from that, roads and taxes. Since they passed that, taxes have also been taken away from them, and they're dealt with separately somewhere else. Okay, now the mining preemption law, I'm going to read the relevant part here. Nothing in this title shall be construed to prevent any local government from enacting or enforcing local zoning ordinances or laws which determine permissible uses in zoning districts. Did you hear a word about zoning in the oil and gas law? All right, those are the two statutes the two judges decided are essentially the same. And you need to judge for yourself whether what I just read you is different or the same. Okay, then there's some principles of statutory interpretation that are very well established. I looked up American jurisprudence, and what are some of the principles that courts are supposed to apply? Well, one of them is the word all. When the statute about oil and gas says that all local ordinances are preempted, all means everything. And then if the legislature wants to carve anything out, as they did in the oil and gas law, they can do that, and they carved out roads, and they carved out taxes. Over in the mining law, mining reclamation law, they said zoning was specifically said zoning was permissible. They didn't say that in the oil and gas law. So the issue before the judges were, are those the same? Do we imply that because the legislature, when it said roads and taxes are carved out from the exemption, from the preemption, because they failed to mention zoning, does that mean zoning's still good? Well, the court thought so. They also drew a distinction in both of the pending decisions